The year was 1976, peak of the emergency promulgated by then Prime Minister Indira Gandhi. Elsewhere in the world, global powers were engaged in a Cold War, and there was suspicion of the ubiquitous foreign hand in domestic politics. Enter Foreign Contributions Regulation Act, or FCRA. The point of the law was to stop this foreign interference in domestic politics. And how did it do that? It did this by prohibiting foreign contributions to political parties, electoral candidates, and even cartoonists. Now, since then, India set out on a path of liberalization. FCRA also evolved in 2010, and subsequently it was made more stringent. For good or for worse is a question that needs answering. But right here, let me take you back to the turn of the century again in 1999. We had FEMA, which was Foreign Exchange Management Act, that was introduced. Now, both the laws, in a way, for different purposes, regulate foreign funds that come to the India that are utilized. But both the laws have been in the news lately for how they are used against NGOs and civil rights organizations, which is why these are the two laws that we'll be talking about in today's episode of Laws of the Land. For this, again, you have me, you have Bhadra, Sinha, and you have Deepak Joshi, who practices in various courts of Delhi. Deepak, it's very interesting because Deepak is a practicing advocate, but he's also a fellow chartered accountant. So nobody better to talk about these two laws than him. Welcome to the show, Deepak.
Thank you.
Deepak, just to start off, Bhadra, if you'd like to take it
Yeah,
forward from
Deepak,
here.
so as Apoorva has pointed out, there was a reason and an objective why this law was brought into force during emergency to probably curtail or prohibit foreign interference, foreign hand in, in the governance, in domestic governance. But yes, it has evolved. So before we talk about how this law has evolved, if you could just tell us briefly, why was this law really introduced?
Okay, sure. So as the name suggests, it's Foreign Contribution Regulation Act of 1976. Now, most people think that it was rushed through in the emergency era. There is a bit of a background to it, half a decade background. I'll just take a few seconds on it. There was an inkling in the minds of the parliamentarians that in the late 60s and early 70s, the nations on the western horizon as well as on the eastern horizon had given up on modern warfare.
Okay.
And they were interfering in local politics and institution through the power of money.
Okay.
And investing, donating, taking the route of charities to influence the decision making and the civil society of the nations. That's when, for the first time in 1969 in the parliament, there was a concern raised by the then Home Minister about regulating these foreign contributions. And that set the ball rolling. And in 1973 is when actually the bill was introduced.
Okay.
It wasn't passed at that point in time. But yes, correctly, the emergency sort of pushed the agenda, put it on a fast track. And with this concern in mind, the debates took place for the first time in 1976. Very interesting readings. They make a mention of KGB, CIA,
Okay.
yes, and several presidents of United States, their interferences. So that kind of concern was there in the minds of the parliamentarians, and with an intent to protect parliamentarian institutions, judiciary of that time, and the civil society, this act was enacted.
So was it a unanimous decision-making process, in the sense were all the parties on board with having this kind of a law?
Interestingly, in Rajya Sabha debate, there were only 4 interventions.
Okay.
But they were very lengthy interventions. There were socialists on one side who were worried what will happen to a scholarship given to a student, what will happen to the monetary funding given by IMF or United Nations. So these well-sounded concerns were also raised.
Okay.
However, as you know, this was an emergency era. Most of the dissenters were not in the parliament at that point in time.
Right.
So the bill was very easily passed.
Since you mentioned the debates, actually for our viewers, in case you are interested, because I got very interested when you mentioned those, I'll have Deepak share those links with me of those debates, and we'll put it in the description so that in case you want to read up more, this will make a good further reading for all of you.
So I had another question, Apoorva, as we go on with this discussion. So as Apoorva spoke about the law's evolution, And as she said, that the evolution happened when India actually went on the path of liberalization. So do you see that the evolution of this law, do you see the objective of the law changing with its evolution, or do you think the objective remains the same?
So on the evolution of the law, when it began, it was far more concessional and liberal in its objective.
Okay.
On a reading of the evolution, as we'll discuss thus further, what has happened is that something which I call an inverted pyramid or a funnel kind of structure. When the act came, there was far more liberty given to the NGOs and registered beneficiaries of foreign contribution. This was in 1976. Ironically, after every kind of amendment, that liberty got diminished, curtailed. And now it's far more stricter, restrictive in that sense. So possibly the objective at that point in time was a little different than what it has come off now.
So does it mean that we are suspecting more of foreign hand or foreign interventions and interference? It's just a very light-hearted, yeah.
Okay, so now since you mentioned about the evolution, let's take our viewers to that. Talk about the evolution, but also when you talk about that, after that, I'd also like you to talk about the law, how it stands currently. What does it say and what are the requirements? Because we do read a lot about FCRA in the news. We read about how it has been used by successive governments. But what exactly does that use mean, or does that use entail?
Yeah, and I think if you could just briefly talk about the amendments and how it has become stricter.
Yes,
as well.
I will.
Yeah.
So when the act was passed for the first time, there were three options before the lawmakers: an outright prohibition on receiving any foreign contribution. Second was regulation, which is in terms of prior approval from the government. The third was no prior approval, no prohibition. The beneficiary just intimates the government that it has gotten the foreign contribution. Initially, the act as stood had a mix of all these three things. Interestingly, NGOs at that point in time did not have a prior registration, prior approval, or a prohibition upon them. They merely had to intimate that they've gotten this much of amount for this much of objectives to be fulfilled. Now, as the structure stood, Section 3, Section 5, Section 7 contained the prohibitions under the Act. Then there were prior approvals which were granted, and then the machinery provisions took place where inspection, audit, or any penalty was levied. After the events of 1984, the circumstances were such that again the concerns were that there are voluntary organizations who are trying to sort of manipulate the public opinion and are infiltrating the civil society. With that in mind, the first set of amendments were brought in. It was preceded by a 1984 ordinance, which was confirmed by way of 1985 amendments.
Okay.
Therein, for the first time, the issue of registration of the NGOs came
into picture. Okay.
So now you can compare that earlier NGOs were free. They just had to intimate. Now the scope got
the inward triangle.
Yes.
Yeah.
So
just to come in here, the 84 event which we are really referring to over here is probably the assassination of our former Prime Minister Indira Gandhi.
Yes.
Okay.
Yeah.
So the law became, the first step to making the law stringent was after the assassination.
Yes.
Okay.
Not only that, under Section 7, even as it stands today, the genesis of that is in 1985. Earlier, only direct funding from a foreign source was captured into the regulation or prohibition route. It was in 1985 that the government realized that there are some institutions who get the funding from the foreign source and then distribute it further to other institutions, which was not covered by the 1976 Act.
Okay.
So this was for the first time covered by way of an amendment in 1985. And this has carried forward in the new avatar of the Act in 2010. So again, this makes it more stringent, expansive in terms of its coverage. After that, 2006 is when the government realizes that there is some deficiency, operational inefficiency in how the whole structure is working. They need to overhaul the system, and a bill was for the first time moved to repeal the 1976 Act.
Okay.
But that bill couldn't come to fruition. And eventually in 2010 is when the new avatar was again
Yes.
introduced, carrying forward the old legacy provisions and countering the issues faced by the legacy.
Tell us about the new law.
Yes. The new law had, as you've rightly pointed out, continued the legacy, but it made provisions more stringent than the original thought process. As I've already mentioned, Section 3, 4, 5, and 7 contained prohibitions. The list of those prohibitions kept on increasing. And the list of interference, the powers to interfere in the functioning and inspection and audit of an NGO also kept on increasing by way of several amendments, either to the primary legislation, which is the Act itself, or under the rules they are made up thereunder. Because prior to the 2010 Act, the rules were not, so to say, properly enforced. Now we have primarily two set of rules which are framed under the Act, which govern the provisions relating to filing of returns, compliances, having a bank account, a dedicated bank account, and the penalties attached thereto. It was still testing waters when there was a minor inconvenience caused to the political parties by way of a provision. We'll come to that later when we discuss it. And those are two further amendments. There are only 4 amendments in the life of this law.
Okay.
We've already covered 3 of them,
Right.
but they're far-reaching amendments. And around 2014-15 is when the elections took place and the new government came into picture. That's when an active interest in governing and regulating the NGO aspect of the law came into picture.
This is when the 2020
Yes.
amendments happened.
That's when the 2020 amendments come into the picture, and these are sort of a mini FCRA in themselves. These are set of 9 to 10 amendments which have changed the face of FCRA as compared to even 76 Act or the 2010 initial Act.
Okay.
So we can discuss how it does, because that package of 10 amendments is very restrictive in nature and increases the compliance burden of the beneficiaries.
Tell us about this compliance burdens. Actually, that's what we wanted to get to next, because of course we talk about FCRA violations, but what exactly are they violating? What sort of burdens are these?
Yes. So a lot depend on the nature of the NGO. Now there is a very vague section in the FCRA
Okay.
which says that a prior registration is necessary for certain organizations, associations which deal with cultural, religious, social objectives. If there is no prior registration, at least you will have a prior approval before receiving any financial contribution from foreign source. Now, how do you receive that contribution? Earlier, there was no need for an NGO to have a designated bank account, which is mandated by the government. Now, whether today, under the amended law, whether the NGO is in Kashmir, whether the NGO is down in Kanyakumari, there is only one dedicated bank account, which is in Delhi.
In Delhi.
Sansad Marg, SBI.
SBI,
So that paperwork, that cost of transaction, that compliance cost, they need to have a person locally situated in Delhi to facilitate the transactions. That increases. Second, earlier the government only had the powers to inspect the accounts, whether the accounts are properly maintained or not. Now they have the powers to even audit the accounts. So that interference has now driven home.
By a third party auditor,
Yes,
auditing of
or a
an
government
NGO's
appointed.
accounts can be done now.
Yes, by a government. So auditing normally happens. That is taken care of by the income tax provisions. But the government can independently now say that I am not satisfied with the audits.
Okay.
So I am going to look into your audit accounts.
Okay.
So these are some examples where the compliance cost or the interference has increased. The second bit is that they have also now captured the indirect foreign contribution through an indirect foreign source that I was talking about. Earlier it was allowed by way of a prior approval. Now it's been completely prohibited. So look at the fate of those regional NGOs who are not that large in size and hence don't attract direct funding from overseas entities. Now they were under an umbrella NGO and the umbrella NGO used to get all the funding on their behalf. Now that source has been sort of cut off because that indirect transfer or a sub-grant of a grant already received
Yeah.
has been prohibited totally.
Right.
So then, if this is a prohibition, then how do these smaller NGOs how can they get part of foreign funding? Is it possible now or no?
It's a very interesting question you put up. This was exactly the question before the Honorable Supreme Court
Yeah.
in a very recent judgment.
Yes.
The Honorable Supreme Court has upheld this part of the law.
Yes.
In one of the reasonings, what they say is that time has come that there are enough people who want to donate for good causes in India locally. And a country like India should not be relying on foreign contribution. Third world countries may do so. These are the lines of the Supreme Court.
Yeah.
But India is in a situation where there are many people who want to contribute for the good causes. Perhaps these NGOs can tap those resources better. That's the answer given. But practically, of course, on ground, we've been seeing it becomes a bit difficult for
Right.
these ground level NGOs to tap funds.
So when we talk about NGOs and the kind of organizations that can actually apply for FCRA, is it defined? Does the law define the kind or the type of an NGO which can actually seek contribution under FCRA?
Yes, it does. To the extent that it classifies different classes, doesn't define them that what comes under these classes. There is a circular given by the Ministry of Home Affairs, which is an illustrative circular. For example, they have said that in the religious organization, what all activities are covered. In an organization which targets social causes, what all activities are covered. But that's a illustrative list. Nothing is contained in the act, so to say.
Yeah, so which means an NGO has to first register itself with a specific authority.
Yes.
Which authority would that be?
That's the central government.
Central
person
government.
Notified by the
Then the central government will give that NGO approval to accept foreign funds. Is that so?
Just a clarity. If the NGO seeks registration,
Yeah.
the NGO will be given a registration certificate,
Okay.
which will be valid for a period of 5
Yeah, that's what I wanted to know. Is there any validity period?
Yes.
Okay. So,
Earlier
But it
in
wasn't
the
there
1976 Act, it wasn't there.
so this is how
Yes.
the law has become stringent.
Yes,
So what happens after 5 years then?
It's good that you put up this question because this is also one of the sources of discomfort for the NGOs. At the time of renewal, now under the amendment, the central government has been given the power to investigate the work of the NGO. And if they find that the work is not being carried out with the object of the NGO, then they can freeze whatever money is in the bank account lying unutilized.
Okay.
And no further contribution can enter into that bank account unless this inquiry is over.
Okay.
So this is at the point of renewal. Earlier there was no such provision. There was a provision to freeze the account, but only after the NGO has been found guilty.
Guilty.
So-
So even before the
Yes.
accounts can be frozen even before the inquiry ends or
Yes.
indicts the NGO.
Yes.
Okay. And on what basis can the approval be cancelled by
So
the government?
It's an omnibus section which says that for the contraventions of this act,
That is not.
it's a very omnibus. Now the contravention of the act, they can levy allegations that you've received funding when you were not registered. You've utilized the funding for purposes you were not meant to. You have not registered under FCRA, but you have registered under a sister legislation.
Or FEMA,
FEMA or
which is
something,
where
yes.
I want. Can you explain that bit? Because I was going to ask that because a lot of NGOs lately have come under the scanner and with the allegation, ED alleging that these are the NGOs who were trying to get a cover under FEMA, whereas and to evade FCRA. So how, if you could explain that?
So FEMA, the law related to FEMA was always in the country since independence. There was a regulation act, FEMA, Foreign Exchange Regulation Act of 1947, which got repealed. Then there was a 1973 Act, which was before this FCRA
came
and
into
then
picture.
it was overhauled by way of globalization and all. 1999 is where we stand.
Right.
The objective of FEMA is to control the movement of foreign exchange, foreign investment into India and outward investment from India. What the government of the day alleges is that that objective is not covered by FCRA. So FCRA is a separate legislation which controls the internal working and the utilization of foreign contribution, which may be detrimental to the interests of sovereignty of India. This objective is not captured by FEMA. And hence, mere registration or approval by RBI under FEMA does not give the transaction a color of legality.
Right, because they say that the purpose of those funds is different, right? If you could explain that also a bit, because as I understand, under FCRA, it's about contributions, say for other charitable purposes, for example. But FEMA, they say, is for commercial purposes, and so the regulations are different. But how do NGOs come under the entire net? Is like both the laws is?
And are the NGOs required to be registered under both the laws?
It's a difficult situation for the NGOs. The reporting ministry for both the laws is different.
That's right.
FCRA is Ministry of Home Affairs and FEMA is Ministry of Finance. Necessarily, both the officers say that you have to register separately.
Okay.
The reason why the objects are not matching is that under FEMA, it's primarily to do with movement of funds. Whether it's a round-tripping allegation of funds, or the RBI may want that we must maintain forex reserves in India, so foreign exchange should not go out of India. So there are regulations to that effect. There are two classes of transactions under FEMA. One is a current transaction, the other is a capital transaction, current account transaction. The normal rule under FEMA, which is governed by section 5, 6 and 7, is that current account transactions are allowed per se unless prohibited. So there is a list under the regulations that sab kuch allowed hai except for these transactions. It's to the contrary on capital transactions. They say capital transactions are prohibited unless specifically allowed by the government. Now here's the catch. Most of these grants are for the purposes, let's say an NGO receives a grant for a funding to establish a school or to aid education or upliftment of poor people or backward society. These are creating assets in rural India on ground level, right? And by their very nature, they are captured in the capital account transaction route. Now, under the FEMA, the reporting requirements and compliances are completely different. You have to fill up different forms. There are annual compliances which are meant to be there. The characterization of those transactions is different. Now, the same money is flowing to a bank account in India. There are two different requirements of compliances. The NGO will have to file one form under the FEMA authority, a different form under the FCRA authority. So you can see that even if the NGO is registered under both the laws, there is still a lot of complication which goes into the characterization of transactions. And the RBI has mandated the banks to give a remittance certificate that this is the purpose for which the amount came to the bank account of an Indian entity. That's under FEMA. There is no such requirement under FCRA. So how do you sort of satisfy the government that this was the purpose and this has been utilized for this purpose?
So there's a sort of an overlap and confusion there as to what NGOs are supposed to do. Now, just to take you back for a minute, because this might be interesting for our viewers, the political parties bit. That was the legacy of the 1976 law, the sort of insecurities that came during the emergency, because of which political parties were also put under the net of this law. What happened post that?
So they've been not only put under the net of this law, they are in the list of the prohibited parties who can never ever receive foreign contribution. And that is why the characterization of political party becomes necessary. What had happened was the national political parties of the country had received certain foreign contribution. That was the allegation in a PIL before the Honorable Delhi High Court. The political party said that this is not a foreign contribution because this is not from a foreign source. So both these words are defined under the FCRA. They took the defense that the company which has given us the money is an Indian entity. It's registered under the laws of India. So there is no question of a foreign interference. The PIL petitioner argued that even if they are registered in India, by an interpretation of the word foreign source and the clauses there under, they are controlled by a party which is registered outside India because the shareholding is more than 50%. So a foreign entity holds more than 50% shares in an Indian entity. That Indian entity is giving funding to the political parties. The Honorable Delhi High Court, in a very well-reasoned judgment, ruled against these political parties and said that you have contravened the provisions of FCRA because by whatever lens you look at it, even under commercial transaction or prima facie view, a foreign entity, if it holds more than 50% in a local Indian entity, it controls the functioning of that entity. And if it controls the functioning of that Indian entity, the funding can be related to the foreign entity. The defense put up by the political parties was very interesting, that they have received the approval of RBI under FEMA.
Yeah.
So if they've received it under FEMA and it complies with FEMA overall cap of investment in India, then there is no
Violation
So
under
everybody's
FCRA.
tried to take that route, or there is an overlap that sort of everybody acknowledges, but
Yes.
it exists.
Unfortunate for the political parties, the court ruled against them. This was in 2014. They appealed to the Supreme Court on this matter. When they were seeing that the matter is not seeing any solution or there is no headway in the matter, they took matters in their own hand. And by 2 successive amendments, surprisingly by way of a Finance Act,
Right.
they amended the definition of foreign sources and specifically excluded those entities where the foreign participation is more than 50%, but they comply with FEMA.
So they would not be considered as foreign source.
So if they are not considered as foreign source, then they are entitled to give funding to the political parties, and the political parties have not contravened anything. The question arises that amendment was subsequent to the judgment. So in the first amendment, they retrospectively amended the law from 2010. That was the 2016 amendment. Very interesting and very rare to be seen. In 2018, they realized a mistake, that the PIL petitioner had actually alleged contravention from 1976.
Okay.
So they
So
amended it.
So they didn't amend the act, they amended the amendment itself, which is very rare to be seen.
Okay.
So in 2018, the amendment of 2016 was amended. The date of 2010 was changed to 1976.
And
that's how.
I don't think this specific amendment is under challenge, but of course the Finance Act, the larger issues surrounding the Finance Act is under challenge.
You're right.
Yeah.
Because Finance Act is a money bill.
Yeah.
How can such an amendment be brought through a money bill when it doesn't really pertain to money affairs?
Yeah.
It's a pure question of law and characterization.
I have a question. The MHA recently removed some crucial data from the FCRA website. This is with regard to the NGOs, which earlier, the website earlier used to provide the entire data about the NGOs, the approval which they have received, plus their audited sheets. All the details were there, but somehow they have removed all this information now, so it is no longer transparent as it used to be. So is that allowed under the rules now? Is that permissible, or is this in violation of some rules?
So,
in the sense, what I want to know is that can the public get to know which NGO has received what kind of funding, how much, what is the list of approved NGOs receiving FCRA? Is all this in public domain or not?
So you are right to a certain extent that this was in public domain on the website. With the amendment of 2020, and there is a new set of rules also which have been recently brought in, an amendment in the rules. What those rules say is that we are now doing away with your quarterly or half-yearly requirements of updating us about your contributions. You file a single return, which is an annual return.
Okay.
You deposit that annual return with us.
Okay.
We'll scrutinize it to our satisfaction and let you know if there is any thing to be done about it.
Okay.
Now, under the law, there is no obligation either on the NGOs or on the government to provide to the public the data of approved NGOs or the balance sheets or the amount which is there. Of course, by way of various press releases, the government from time to time gives a figure that this is the number of registration, this is the number of cancellations that we've done. In fact, they use that number to justify the amendments in the objects and reasons statement.
Yeah.
Okay, so just another question here before we close. Now, you spoke about that inverted pyramid when it came to evolution of the law, and we've spoken about the amendments that have come in. But how has that evolution been when it comes to judicial pronouncements? A little bit on that, because we had a very important judgment, a very interesting one at that, which came out recently, where
Upholding
the
the
amendments were
Yeah.
challenged and they were upheld. So how has that evolution also been an inverted pyramid? If you could tell our viewers that.
So I'll start with the recent Supreme Court judgment. The issue, as you know, was a bouquet of those 10 amendments
Yeah.
in the 2020 amendment list. The Supreme Court has put on pedestal the interest of the state and has completely rejected the argument that an NGO or an association has the right to receive foreign contribution. Why I'm pointing out this is that few months before this judgment, there was another judgment, I think by a bench of leading by Justice Rao, which is the Insaf judgment. There they've categorically recognized that there is a vested right and a fundamental right to receive contribution. So there is a quantum leap of faith, so to say, in the understanding of the judgment of the Supreme Court. The later judgment deals with that judgment, but not in a very satisfactory manner. So in that sense, yes, the view has restricted
yeah.
to a certain extent. Even otherwise, in the Delhi High Court judgment of those political parties and the Supreme Court judgment which preceded the latest one, the view taken was that you ought to further the object of the act, which is to stop interference from outside. But that should ordinarily not interfere with the local working of the NGOs. It shouldn't be an interference into their daily, day-to-day affairs or to stifle any growth of an NGO base in India. That has not been considered by the Honorable Supreme Court in the recent judgment, which is Noel Harper. That's the name
Noel
of-
Harper, yeah.
That's the name of the judgment. In doing so, they upheld all the challenged provisions of the amendment, and they don't deal with these two judgments at all. Preceding judgments. Unfortunate, because it could have made the judgment more reasoned,
Right.
and we could have views from both the sides and then decide for ourselves.
So basically, what you're trying to say is that regulation doesn't mean that it should lead to, too many interventions by the government, which unfortunately has happened, and which the Supreme Court judgment also upholds.
Yes, just for an example, the last judgment, Insaf judgment, there the issue was that certain entities are not political parties, but they are in the nature of political parties. So by way of expansion, they get covered under the prohibition. Now, who decides that which entity is in the nature of a political party and what is the consequence of that? Supreme Court read down the rules and the provision to say that activities like strike, Bharat Roko, ya Bandh, they are not in themselves satisfactory to levy the tag of
a political
party. So that's a very liberating judgment.
Right.
So in that sense, the Supreme Court and the High Court have been taking regular view that a little bit of liberty is still allowed under FCRA.
But this recent judgment sort of sets it
back. Yeah.
With this, we've reached the end of this episode. Like Deepak and Bhadra also pointed out, FCRA began in the 1960s. The idea was sown in the 1960s, but since then, the law has evolved through amendments as well as judicial pronouncements. As it stands right now, it looks like the evolution, though, has been in the form of an inverted pyramid, where the restrictions, the laws have closed in on the NGOs, the restrictions have hardened, and we also spoke a bit about how FEMA plays a role in this. Do let us know what you think about this episode, what you think about this new series that we've started. We always read your comments, so do let us know in the comments section and follow us on social media. Thank you.